Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. So today's question is, how hard is it to change bankruptcy trustee and what's the procedure? So a change of bankruptcy trustee cannot be initiated or put in place by the person going through bankruptcy. This is a process available to creditors in the bankrupt estate, and it is quite possible and quite common that the existing bankruptcy trustee will need to be sufficiently comfortable that that person is a genuine creditor of the bankrupt estate. Now, the actual procedure itself, there's two main ways that a bankruptcy trustee for bankrupt estate may change. Firstly, there's the streamline procedure. Now, for anyone technical, this is in section 181 capital A of the Bankruptcy Act. And what happens is the creditor reaches out to the existing bankruptcy trustee and says that they wish for a new bankruptcy trustee to be appointed in place of the old one. The existing one might agree for whatever reason to that, in which case the streamlined process of replacement of bankruptcy trustee happens. In summary, that is that the existing bankruptcy trustee issues a notice to all creditors of the bankrupt estate saying that there's a proposed change of trustee, and if in about 2 weeks there are no objections from creditors, then that change will take place. An alternative method is by a meeting of creditors. So sometimes a bankruptcy trustee might not agree to an automatic change of bankruptcy trustee for the estate. In that case, if creditors have sufficient numbers and fulfill the requirements in order for them to request a meeting of creditors to be called, and if the bankruptcy trustee does call that meeting of creditors, creditors can then vote at that meeting as to whether they wish to remove the existing bankruptcy trustee and replace them with a new one. So this vote usually requires the majority in number and majority in value of creditors voting at that meeting in order for the resolution to pass. Coming back to the initial part of the question, how hard is it? It varies from bankrupt estate to bankrupt estate. Sometimes the process is quite straightforward. Other times it can be highly contentious, and in the extreme, it can even involve a court dispute, for example, on the adjudication of creditors' claims, and hence if the voting thresholds were met or not met. So to summarise, it's a procedure available to creditors, and it can vary from quite straightforward to quite complex.